Well, howdy, everyone. This has gone swimmingly so far. I'm David Glazer. I'm just here to do a quick introduction before we start talking about social media and the healthcare worker. You know, things like when you take pictures of people's body parts and send them out. Not that that would ever happen. So before we dive into the substance, just a couple of quick announcements. So first off, next month's webinar, which will be this time on May 13th, is going to feature Jim Platt and Katie Douglas talking about professional services arrangements, PSAs. That's going to be a big deal. I think most of you probably know what that is, but basically it's the idea of physicians serving as independent contractors with a hospital and providing the medical services that way. It's a big deal. It's a big topic, and I encourage you to sign in. Remember that all of our past webinars over the last couple of years are available on SlideShare. The email that you got with the confirming the information for today, both of those emails should have a link to that, and you will get one when you get your email with the credits, so you can go listen to any of the past webinars, and just like this one, it's free. Finally, the internet, it can be balky, and so if the sound goes to heck in a handbasket while you're listening, you can always dial in, and the only reason we don't do that is we pay for the dial-ins, but if you can't hear, dial in. Robert is right now sending out in the lower right corner the dial-in number. If for some reason you can't see the chat box, remember you can always take your mouse up into the middle of the screen, and you will see options for getting your chat box and other things. And that's where you ask questions. And you can ask questions of Teresa and Nora, which brings me to Teresa and Nora. So Teresa Thompson and Nora Olson-Bluestein are two of our employment lawyers. They're shareholders of our employment law group, and they both give advice on the kind of risk management side. And then when things go poorly, they'll deal with the litigation. So if you've got an employment problem, some of you I know have been lucky enough to deal with either Teresa or Nora in the past because they've worked with a bunch of our healthcare clients. But they are here to talk today about social media. And I will just put in one mention. I think they are happy to do training for you they can do it on a remote basis, on a fixed fee basis. If you like what you hear today and you feel like you want to train your staff, they're available to do that, and they can do it from here. So if you're sitting right now in Hawaii or in Alaska, while they would love to come and join you, they can also do that from here. So without further ado, let me give you, we're going to start off with Teresa Thompson. Take it away.
All right. Thank you, David. We certainly appreciate the introduction, and we appreciate everybody's patience as we got things moving here today. So we are going to jump right in to talk about social media and the healthcare worker, but I want to say that we do have some people on the line that I think that are not in the healthcare industry, and what we are talking about here today applies equally to other industries. Our examples, however, probably tend to focus more on healthcare, but certainly is applicable across the board. So first, let's just talk about, why do you care about social media? I know at least we are long past the idea of just saying, what is social media? Now patients are using social media. They're talking about your clinic or your organization on social media. And so doctors and clinics need to be able to use social media and understand social media as well. Not only are your patients using social media, but your employees use social media, as many of you know. Their conduct on social media can certainly affect the workplace, it can impact patient care, and it can impact morale within the organization. So managers and supervisors certainly need to understand how to handle employees' conduct on social media without creating legal liability, and there are a lot of pitfalls that we're going to talk about here today. So today's agenda, as we go forward, we are going to talk about, first off, Facebook firings, do's and don'ts. You would be surprised that despite the fact that Facebook has been around for a long time and has as many users as it does, that there are still issues with regard to employees engaging in bad conduct on social media, and clients call us all the time saying, "Can't I fire this person?" Nora is going to talk to you a little bit about that. We're going to talk about employee and patient privacy rights. There are a lot of issues with regard to posts on social media, and it impacts privacy rights on both ends. We'll talk a little bit about social media in hiring, some of the do's and don'ts relating to that. And finally, we're going to end today talking about protecting your brand online. We have a lot of clients, healthcare clients in particular, who are calling us saying, what can we do about a patient post online or an employee post online. And we'll talk about that too.
Great. So let's start with my favorite topic, Facebook firings. And we're going to try to do sort of a question and answer format. So let's take our first question. I can fire my employee for his Facebook post, right? Well, if you are fortunate enough or unfortunate enough to deal with a situation like we have on screen here, where you've got an employee using the sink at work to take a bath and then post it on Facebook or YouTube, that's a pretty clear-cut one. I would say go ahead and fire that person. Most likely, the situation will be a little bit more complicated, and before you jump in and pull the trigger and fire somebody, you should just take some time to evaluate whether what the post is about is somehow protected. The big one that we tend to talk about in terms of why posts might be protected is the National Labor Relations Act. This law has been around for decades, since the New Deal. It applies both to union and non-union workforces, even though we oftentimes think about it more in the union context. And Section 7 of the NLRA says that, in essence, employees have the right to discuss the terms and conditions of their employment. Some things to think about here. Terms and conditions of employment is an extremely broad term. Anything relating to an employee's wages, compensation, how their supervisors are treating them, those are Section 7 rights. Employees have the right to talk about those things with one another. That even means they have the right to criticize their supervisors and management. And that's what we're going to see a lot on social media. As a little side note, the NLRB, which is the agency that oversees the NLRA, they are focused very heavily on social media firing cases. And when they get into those cases, they're looking at company policies to see if those policies just by themselves violate the NLRA. So that's a big topic that we've been advising employers on. If you think about an employee handbook, some policies that tend to come under fire include social media policies, computer use policies, but even policies like confidentiality, where you might be talking about keeping employee information confidential, employee conduct policies, things like that. Those, if you haven't had your policies updated recently, you should think about doing that, because the NLRA has been, or the NLRB has been really focused on those, and we need to make sure that your policies are up to date. So that's a little sidetrack here. Other laws that might be implicated by social media posts when you're thinking about firing somebody based on their post. Whistleblower laws. Is the employee using social media to complain about illegal conduct? Similarly, civil rights laws. Is the employee complaining on social media about harassment or discrimination? We'll have a case in a few minutes that relates to the FMLA, but we're also seeing cases relating to ADA where perhaps the employee is disclosing a disability on social media. So we're going to give you some examples now to see how these laws come into play when you're trying to handle an employee post online. So the American Medical Response case, this is really how all of this got started, where we started talking about Facebook firing cases. So here the employee works as a paramedic, and they post, "Looks like I'm getting some time off. Love how the company allows a 17, which is a code for a psychiatric patient, to be a supervisor." Then a coworker responds, "What happened?" And the employee says, "Oh, it's Frank being a dick, he's a scumbag," and the coworker responds, "Chin up." So the employee got fired for these posts, and if this was several years ago, we would have been supportive of that. The posts are very derogatory, but the problem is that these employees have the right to criticize their supervisor online. So the NLRB actually found that this termination was unlawful. In contrast, let me give you a few examples where the termination was not unlawful. The posts were not protected. In the Martin House case, Martin House is a shelter for homeless employees, or homeless people. They had an employee post about somebody staying at the shelter. Then they called him Spooky. And they talk about how Spooky is overnight on the 3rd floor. And then the employee posts about how another client is cracking up at her post. I don't know if she's laughing at me, with me, or at her voices. Blah, blah, blah. So essentially making fun of the people who are staying at the shelter. That employee got terminated and brought an unfair labor practice charge under the NLRA, but they found that the termination was not unlawful. So what was the difference here? Well, they're not discussing terms and conditions of employment, and no coworkers responded. This employee was just sending out these posts and didn't get a response. So it's factors like that that made the difference here. We have another example with a dermatology clinic. They had a really angry, disgruntled employee essentially dare the supervisor to fire the person, and the supervisor took them up on their comment and did fire her. And when she claimed that this post was protected because she has the right to badmouth her supervisor, that was not upheld. They found that no other coworkers joined in the criticism, so that made a huge difference. So to be protected, it needs to not just be a single employee. It's got to be employees banding together to try to change something in the workplace. And here the employee was just ranting on social media and nobody responded. So posts like this, and if you terminate somebody for that, it hopefully would not be considered protected. Another example of a post that was not protected was not an NLRA case. Instead, this is an FMLA case. So here we have a nurse. She was on FMLA. She went on vacation, which was pre-approved, so the employer was not upset about her going on vacation even though she was on FMLA. But what happened then is she posted a bunch of pictures of herself on vacation doing activities that she claimed she couldn't do in the workplace. So it's very similar to cases we've seen a long time ago where you've got, for example, a workers' comp private investigator going out and catching somebody on videotape playing baseball and hitting a ball when they have a shoulder injury. So it's not consistent. You can tell they're lying. So here it's the same thing. She claims she can't do this or that at work, but then she posts pictures of herself online doing that same activity. So here the termination was not unlawful because she was essentially terminated for lying, and she did not have an FMLA claim. So what are our practical takeaways to all of this? The first thing is, if somebody posts something online that you think should result in them being terminated, you may very well be able to terminate if that's the right thing to do, but before you do that, you need to think about whether the post is protected. The big one to focus on is the NLRA. So some things to look at. Is the employee a supervisor? Supervisors are not covered by that law, so they don't have the same protection that rank and file employees do. Second, does the post relate to terms and conditions of employment? And remember, that's a really broad concept. Next, look at, is the employee Facebook friends with coworkers, and did coworkers respond to the post? So if you look at those factors, that will help you make a more informed decision. But then I would also step back and look at this from a little bit more of a distance and think about whether the post really justifies termination. There definitely will be posts that justify termination, but to some degree, think about whether you should just let that one go, get a thick skin. In a few days or minutes, the post will be so far down the chain, no one will see it. So think about those things too. Sometimes it's better just to let things go.
Well, it's interesting because one of the things that comes up when we're looking at Facebook posts in particular is, how did you actually get access to that Facebook post? And so that raises the question of employee privacy rights. And so we're going to start with a question again, which is, I think that one of my employees is violating the clinic's social media policy. I can monitor his or her social media activity, right? Well, that may depend. The easy answer is that public information is fair game. If somebody maintains a public Facebook page, which permits anybody to look at it, that public information is fair game. If somebody has posted something and actually put their name to it on Craigslist or on Angie's List or on LinkedIn or somewhere else, all of that information is fair game. There is no overriding law that provides privacy to anybody who is going to post on the internet in a public manner. However, the private information does raise some concern under both state and federal privacy laws. And that is where employers in particular have been getting in trouble. And so one of the things we always want you to do when you're looking at whether you should be viewing a particular Facebook post or other post online is to look at your policies to find out, number one, what does your social media policy say, and what does your computer use policy or electronic monitoring policy say relating to you as an organization monitoring somebody's access to or use of social media on a work computer. So what I'm going to be talking about a little bit here is really to focus on if you are an employer, you want to monitor what an employee is doing online on your computer. That's what I'm going to be talking about. Now, that doesn't necessarily mean that takes me out of the purview of you saying I'm going to go out into the internet and look for information, but just to make clear what we're looking at. And the reason that your social media policy there and your computer use policy is important is you got to be keeping in mind whether or not you have given your employee an expectation of privacy in their use of your equipment. So let's talk about that a little bit more with an example. So the first example here relates to some very non-public information. In the Lizette case, which we've highlighted here, an employee had an employer-provided BlackBerry. Yes, people still do use BlackBerries now and again, but this would apply equally to any sort of mobile device provided to your employees that is actually company-owned. And in this particular situation, the employee was let go or resigned, believed that the personal Gmail account that she had been using to access her personal Gmail account on that device during her employment had been deleted from the device, and that's what she was told. But her supervisor never actually deleted that account. Instead, the supervisor decided that it would be a very good idea to read over 48,000 emails, and these were all personal emails of this individual, after this employee was let go. Nonetheless, the employee found out about this and did not like it and sued for a violation of the Federal Stored Communications Act and also included an invasion of privacy claim. So in this particular instance, the question really was, did this supervisor have authorization to read all of these personal emails? The employer took the position that they had authorization because she accessed them on a mobile device that was provided by the company. The employer moved to dismiss the Stored Communications Act claim, and they did not win that motion to dismiss, and subsequently the case was settled. So we don't know exactly what happened here, but what we do know is that an employee believed that this was an unauthorized access of these particular emails. And this actually comes up more often than you would think because employees do access personal email on company-provided devices. They access personal emails on work-provided computers. They leave their passwords. They use their usernames there. And employers tend to think, well, wait a minute, it's on my device. I should be able to access it. I'm going to ask you right now to sort of step back from that if you want to do that and seek legal counsel about whether or not you actually have the right to do that. And one of the things that you're going to want to look at there is to look again at your computer use policy, your electronic monitoring policy, and your social media policy to see whether or not you've given your employees any expectation of privacy in what they're doing on your devices. Another instance of non-public information was in the Elling case, and this was against a hospital, and it related to a registered nurse who had posted to a private Facebook wall, meaning that she had the appropriate privacy settings to her Facebook account that only permitted friends to look at her posts. Here, she posted regarding an 88-year-old sociopath opening fire at the D.C. Holocaust Museum, and she goes on to say, "I blame the D.C. paramedics. What were you thinking? This was your opportunity to make a difference. WTF." The hospital fired the RN over this particular post, and she sued again, asserting a Stored Communications Act violation. However, in this particular case, the employer prevailed, and the employer prevailed because a coworker voluntarily provided a copy of the post to the employer. The coworker was actually an authorized user, meaning that had authorization to access the Facebook post, and so in this particular situation there was no violation. But it serves as a reminder that if you do not have authorization to access a private social media account, you need to step back and say, do I have authorization, whether via a policy or whether because you're friends with this particular person, or do I not have authorization? Because that is the key to these Stored Communications Act cases. Now, you can create that sort of authorization if you have appropriate policies under certain circumstances, but again, it's one of those that could lead to a claim, so it is worth seeking some legal advice on that particular situation. So what are our practical takeaways on this? Look again at your policy language. Make sure that you use publicly available information whenever you can. There's a lot of public information available. And don't try to pose as somebody else. If you try to pose as somebody else, or you ask a coworker or an employee to give you the information, courts tend to look upon that pretty negatively and have come down in some cases as actually concluding that that is coercion, and so concluding that there was no authorization. And one other practical note here, there are so many supervisors who are friends with other coworkers on Facebook or on other social media sites, and you should really think twice about having supervisors friending supervisees, because there are just a lot of situations where that can lead to bad results. So in addition to employee privacy rights, we've also got patient privacy rights that you need to be thinking about. So some of the examples that you might come across is, I love my job, I can post about it, right? Meaning I can post about the particular patients that I'm treating. Or, I hate my job, and I'm going to post about it whether you like it or not. I actually admit I have a friend on Facebook who is a teacher, and she regularly posts about her days at the office or in the classroom. And I've got to say, some of those posts about her students are things that maybe I would step back and say, maybe you shouldn't do that. Same thing applies to patients. But what about employees who want to friend their patients? Patients want to know more about me. It's okay, right? Or situations where you want to post information about a patient, such as, if I don't say who the patient is, I can post a photo of them. Can I do that? Well, let's talk about it a little bit. As many of you know, and most of you should know, sharing patient information results in legal liability under HIPAA, under state privacy laws, under state health record laws, under state medical laws. There are just a whole host of potential legal liability arising from disclosure of patient information. The same thing applies to disclosure of sensitive information that you might have in your possession if you are a non-health in a non-health industry. So let's go through some specific examples. This one is actually fairly old now, and one of the first Facebook firings of a doctor that we first talked about. In this particular circumstance, a Rhode Island doctor had a really bad day in the ER. And after that day, she went home, she posted on Facebook, she talked about the patient with enough detail that it provided identifiable information of that particular patient. This Rhode Island doctor was fired from her employment. She lost her privileges at the hospital, and this is a very public situation now, and so you question whether or not this particular doctor has been able to find other employment, and what impact does that have on her career, all over one post. Here are some other examples of employees who suffered bad consequences as a result of posting. We have ER nurses and staff who posted photographs of a stabbing victim instead of treating him. Another one of the first circumstances of employees demonstrating lack of judgment with regard to posts on the internet. We had a student nurse who posted a photo of a 3-year-old chemotherapy patient and wrote about how brave the patient was. Now, in this particular circumstance, I'm pretty sure that this student nurse wasn't doing it for an improper purpose. She probably felt as if this was something she needed to share because it impacted her so much. But nonetheless, it violated several privacy laws. What about a student nurse who posted a photo of herself with a human placenta? Nora, really? You had to include that one?
I almost included the picture too, which was really, really gross.
That is out of control. So in all of these circumstances, again, you can see why an employer and an organization would need to take action in order to respond and react to these very public and inappropriate uses of patient information on the internet. This one is a little bit more fun. We've got ABC's New York MedStar, Katie Duke, terminated because she posted photo of a trauma room after a patient was treated there for wounds after being hit by a subway train. Now, importantly, in this particular situation, the patient was no longer in the room. What you saw was an ER room strewn with debris following the treatment of this particular patient. She posted that photo on Instagram with the hashtag man versus 6 train. Not particularly sensitive, and her employer found it to be very insensitive and terminated her employment. I have to say, when looking up this particular situation, I thought that Katie Duke actually responded in a particularly good way. We're talking later about protecting your online brand. Katie Duke certainly did that here by responding and saying, you know what, it probably was insensitive. I probably shouldn't have done it. She owned up to it, and she said, but you know what, we work in the ER. It's a really, really hard place to work, and sometimes this is our coping mechanism of dealing with this. But I shouldn't have done it, and without surprise, she landed on her feet and is now working in the ER in another hospital. So what are your practical takeaways here? As a healthcare organization, I feel that it is critical that you include very specific information regarding your employees' obligation to protect patient rights. Your policy should say, don't discuss the patients in any form or fashion. Don't post any protected health information, including any photos. Please don't friend your patients. And you may even want to include in your social media policy that your employees cannot have their personal cell phones on them while they are providing patient care, because sometimes employees just can't help themselves, whether to include information regarding a particular patient or to include photos. Make sure that your employees understand, whether it's through training or whether it's through including additional information in your social media policy, that really social media, at least as it relates to their work, is professional networking and education.
And I would add, too, that the training piece is really important. A lot of what we see in social media is not really employees doing things for nefarious reasons, but really just inadvertence or lack of understanding of the impact of what they're doing. So training can be really important because you can explain what those impacts are, you can explain why it matters, and you can give examples and tips for what you expect. That being said, the training needs to be sort of carefully balanced to make sure you're not infringing again on employees' rights to discuss terms and conditions of employment at work and things like that. But that educational piece will really go a long way. So now I'm going to move on to the next question, which relates to social media and hiring. I can decide not to hire someone based on what I see on their social media sites, right? Well, as we always say in the law, it depends. You might be able to, but we need to make sure you stay out of legal hot water. So screening applicants using social media implicates a number of different laws. There are state and federal civil rights laws. There's the Federal Fair Credit Reporting Act, and some states have their own state consumer reporting statutes. There are state lawful consumable products laws, which we'll talk about in a little bit. And some states also have social media password laws that might be implicated if you're using social media to screen applicants. With civil rights, the issue basically is it's TMI, it's too much information.
I'm going to pause for a second to just say we know there's apparently some serious technical issue happening on the WebEx end. So if you're on the computers, hopefully you can hear us. But we apologize for the various glitches that are going on, and the audio the recording should be available. Sorry about that, Nora, but please continue.
Okay, thanks, David. So screening applicants with social media, one issue that we worry about is, are you learning too much about the applicant? Are you learning things that relate to protected class information? So are you learning how old the person is in a way that you wouldn't normally learn if you weren't using social media to screen applicants? Do you find out that the employee is expecting a baby? So now you're dealing with a pregnant employee. If you then learn this information and then choose not to hire the applicant, can they somehow make a failure to hire claim? Basically saying, you learned this information on social media, you didn't hire me, it must have been because you were discriminating against me. So that's one caution when using social media in screening applicants. Another one to keep in mind is the Fair Credit Reporting Act. So think about this in terms of using background checks when you're in the hiring process. Using social media to do a social media background check, if you're using a third party, that's the same as a criminal history check. It's covered by the Fair Credit Reporting Act. And there are sort of a niche industry of social media background check companies. Social Intelligence Corporation is one. They had a very interesting New York Times article a year or two ago about what their business is. And I'll give you a quick example. So they use social media, they aggregate and sort of compile a profile of a person's social media content, but then they screen out that protected class information. So there'll be a picture of the person, but it's got blacked out all information showing what the person's gender is, what their skin color is. They go through and censor postings to take out things that might be protected. So it looks like it's sort of been reviewed by a spy agency or something, and it's got blacked out things all over the place. But then they leave in other things, both positive and negative about the person. So with using social media as a background check, if you're using a background check company or any third party, you just need to be aware that you've got to comply with the Fair Credit Reporting Act. The Lawful Consumable Products laws, in plain English, what that means is if an employee is doing something, or an applicant, and it's legal and they're doing it off duty, you can't not hire them for it. And the two ones that come to mind are tobacco use and alcohol use. So if you have, for example, a picture of somebody who's of an appropriate age to be drinking alcohol, they're at a party and they're doing stupid things with a glass of beer in their hand, that is protected. You can't choose not to hire the person based off of that. So it's interesting because it can show that perhaps the applicant has bad judgment, but at the same time, you need to make sure that if you're in a state that has one of these laws, you've got to sort of ignore that and let it go. One thing I try to tell clients when dealing with something like this is another one, it's sort of too much information. If you didn't do the social media check, you wouldn't have seen this post, and perhaps it's better to just let that one go. With social media password laws, many states are prohibiting employers from asking applicants to turn over the login information. So this is another one where it's sort of like you're posing as that person. You're logging in real time to see what's on their social media sites. That's a no-no, and even if you're in a state that doesn't have one of those laws, we don't recommend doing that because you can get the same information elsewhere.
And I just wanted to add in on this social media password legislation. Some of that came about because employers were actually, during the application process, asking employees or applicants to log in to their social media sites so that the person interviewing them could review the social media sites live, or they were asking them to actually provide the social media password so that they could log in and check out what they were doing on private Facebook sites. As you can imagine, there was a lot of hoopla about that, and that is why some of the social media legislation has come about.
Should we take a couple questions, or
do you want to do your practical takeaway?
Okay, so what are the practical takeaways in all of this? You know, we say this a lot with a lot of employer practices. We want you to be thoughtful and planful and then be consistent. So if you're going to use social media to screen applicants, you need to have a plan. You need to know what you're doing so that you can be consistent. So what should that plan include? Here are a few things. Who's doing the searching? By this I mean, are you doing it in-house? Is somebody in your HR department going to be doing it? Or are you going to hire a third-party background check company, social media background check company, something like that? If you're going to hire somebody else to do it, again, you need to make sure that there's compliance with the Fair Credit Reporting Act. If you're doing it in-house, which may be more practical, that also raises some issues. So, for example, it's a good idea to use a non-decision maker. So you don't necessarily want the hiring manager to be the one who's going out and learning all of that protected class information. Instead, use somebody who is peripheral to the process, and then create a firewall so that, kind of like with Social Intelligence Corporation, whoever's doing the screening and gathering that data should know how to sanitize it. So train that person for what they should be looking for and what they shouldn't be looking for. So that leads right into the next one. What are you looking for? Well, you should look for both positive and negative information. We tend to focus more on the negative, but there's a lot of really positive information you can learn about somebody on social media. You can learn about awards they've received, charitable organizations that they contribute time to, things like that. You can get a sense for the person's character, and oftentimes that's really positive. So I would encourage you to look for both positive as well as negative information. But another thing to keep in mind is you should be able to articulate why the information you're gathering is relevant to your organization or to the job. So an analogy here is we say the same thing if you're looking at criminal history. If you've got a criminal conviction that you're evaluating, what is the job relatedness? If you are gathering all sorts of things on social media but you can't explain to your lawyer, much less a judge or jury, why you cared, that's not very compelling. Another thing that you should look at as part of your plan is where and how are you searching. So this is just to keep you organized and consistent. Think about what sites you're going to, or types of sites you're going to look at, and what your basic search strategies are going to be. That way, no matter who the applicant is, you have a general framework for what you're going to follow. Now, that doesn't mean that if you're doing those searches and something unusual comes up, you can't follow that lead. You should still be flexible, but in general, we want you to be consistent so that an applicant can't later say, well, you only looked at these sites for me, but with everybody else you looked at these other sites. And then lastly, when are you searching? We've found that a lot of employers do the social media searching pretty early on in the process. I think because they want to just get a sense for the person. They may be doing the search right after they get the resume or job application. But I would encourage you to consider whether that's the right time. If you do it early in the process, you're then going to be doing your searching on a lot more people versus waiting until later in the process, maybe after an interview, maybe after even a conditional job offer. There's no perfect answer here, but some of it is a balance of, does the person doing the searching really have the time to be searching on that many people? And also, if you wait till later in the process, you'll be learning protected information on fewer people. So essentially, you may be lowering your risk of a failure to hire claim. So those are all things that you want to think about when coming up with your strategies for using social media to screen job applicants.
So that leads into a couple of the questions, so we'll go to those right now. We had a question relating to can an employer check out an applicant's Facebook page? And I think Nora just answered that question. The answer is yes, so long as that information is public. And so long as you aren't asking somebody else to give you access to that information. But the question is whether or not you really should be. And I think Nora just provided a really good answer to that question about, thinking about whether you really need to look at that applicant's Facebook page or whether you want to wait until later on. And I tend to agree with you, Nora. I don't know that there's a good time.
Or whether you want to look at it at all. Some employers have decided that they'll look at professional sites like LinkedIn, and they'll leave Facebook alone because it's, for most people, they're using it for personal reasons, and it really doesn't affect the workplace. Now, that's going to depend on each business, I think, and what the job position is and what the goals are. But at least I wouldn't automatically jump in and look at Facebook without at least thinking about whether it's necessary.
Okay, so this leads to the next question, which is, can you not hire someone because of their Facebook posts?
Potentially, yes, as long as you go through an analysis of what it is you're looking at it and is what you're seeing somehow protected.
And I recently saw an interesting statistic that there are many, many employers who are not hiring employees because of their posts on social media and Facebook in particular. And most of those relate to, and going back to the Lawful consumable products problem, some of those relate to smoking and drinking. Again, people are saying that doesn't fit within our organization. We don't want you here. Some relates to destructive or dangerous activity, or what they consider to be destructive or dangerous activity. Some just relates to exercising bad judgment in what they're providing. But a lot of them are legitimate reasons. And so I think that there might be something that you see on a social media site that gives you the reason not to hire that person. All right, I'm going to ask one more. This one is interesting. So this goes back to not friending patients. So doctors are using social media to share clinical information and news for public consumption. Twitter is a popular platform for this. Is there a problem with consumers following doctors who are interested in their content? The doctors need to accept each person requesting to follow them. What do you think?
That's an interesting one. I think that we would want to be extremely careful that the Twitter account really is for educational news-related items, and that there's not, to the extent you can put into place parameters where we're not getting into an exchange between the doctor and the patient and relating to patient care and things like that. There are people using Twitter merely for professional reasons, it's sort of like having a professional Facebook page. It's very different than when you're mixing both personal and professional.
And I tend to agree as well. I think the concern that we have about employees or doctors friending patients is that there's going to be a desire to talk about protected health information. And I think that's where we have the concern. One more question here before we get on to protecting the online brand is that there was just a question relating how does an organization go about updating policies and procedures to address social media?
Well, I help clients do that all the time. You should see the stack of employee handbooks that I have on my desk. I think that legal counsel is important because these issues are nuanced, and it would be extremely difficult if you're not practicing in this area to stay on top of how this is changing. This is a large part of our practice, and so we help all the time with that. So I think good legal review is a great place to start. If you want to get started yourself and get a legal review when you're done, I think you can get good examples, just for example from our PowerPoint, of things, tips on what to include and what not to include.
So I've got one more question that relates back to some of the things we've already been discussing, so I'm going to take that, and then we've got some additional questions relating to online brands, so I'll just wait on that. And this one is sort of a up in the air, maybe, maybe not question. Can you hire someone for being a smoker, whether I saw this on a post or not? I did not think smoker is a protected class.
That's very interesting. And you're catching me off guard here. So I know that some states have exceptions to their lawful consumable products laws, where if there's sort of a bona fide reason that being a non-smoker matters, let's say you work for a smoking cessation company where their entire mission is to get people to stop smoking, that might be a reason. With healthcare organizations, typically the way we handle this is with tobacco use policies, where you can't use tobacco at work, or you can't come to work smelling of smoke or tobacco, things like that. So you sort of stay away from the fundamental issue of whether somebody is a smoker or not, and instead focus on the behavior and the conduct.
I think that's the right answer. All right, so I'm going to go on and make sure that we talk about protecting your online brand. And the reason that we want to talk about this is because we have so many clients these days who are calling us and saying a patient has posted something so terrible and wrong and false on the internet, what can you do? Or an employee or a former employee has posted negative, disparaging, defamatory information online. What can we do about it? Well, the fact of the matter is that you definitely have the right to respond in some form or fashion to negative online posts. But just like with terminating somebody for a post on Facebook, we always say, number one, let's step back for a minute and ask some questions. And so the first question that I ask, particularly with healthcare providers, is, does the post contain HIPAA-protected information or other sensitive or confidential information? Because if it does, in that particular instance, you do want to take action and you want to respond, whether by sending some information to the provider that has posted it, or meaning the internet provider who has posted it, or by sending a letter to the particular employee. The second question then is to ask, is the post really believable? That is it going to really hurt your company? And if it's not really particularly believable and you don't think it's going to hurt your company, maybe you should step back, get a thick skin, and let it go. Because at some point in time, nobody's going to care about it. And the fact of the matter is, many sites aren't going to take down the posts anyways, unless you can show, for example, that it does contain HIPAA-protected information or other confidential information. They won't take it down if it is simply rude or mean. They might take it down if it is harassing, and you can show that it is causing sufficient angst for your employees, which in some instances you can do that, but many sites simply won't take them down. And Google, where you can find many of these sites, is one of the hardest ones to deal with in getting things to be taken down. Now, the next question that we always get is, can't I bring a defamation claim? We want to sue this person. We want to take action right now. Well, the answer is, of course, if it is false, if it has been published, which clearly it is, and if it's causing damage to your organization, you can bring a defamation claim. But they are very hard to win, and I'm going to give you an example of one of those right now. So this is outside of the healthcare realm, but I thought that it was interesting because in this particular case, it was a contractor who had done some work, Dietz development, for Ms. Perez. Ms. Perez did not like the work that was completed by Dietz, and so she went online and said a whole bunch of bad things about the work that Dietz did for her. Dietz thought those things were false and filed a defamation lawsuit against Perez for the online statements. But in addition to filing the lawsuit, Dietz also went online and made responses to Perez's comments and made allegedly defamatory statements about Perez. So now we've got competing online statements against each other. So Perez, of course, filed counterclaims against Dietz, claiming that the online responses were defamatory. The case went all the way to a jury, and the jury concluded that both parties had defamed the other, meaning that they had made false defamatory statements against the other and caused damage. But the jury was so fed up by the time that it got there, it awarded no damages to either party. So here are two different, an individual and an organization who took a case all the way to the jury, and neither one of them got anything out of it.
But their lawyers did.
Which I don't think is the right result, frankly. There are other cases that we have as well, one in the state of Minnesota that went all the way to the Minnesota Supreme Court, where a doctor, Dr. McKee, actually sued one of his patients for posts online. This went on for years and years and years before it went to the Supreme Court, and in the end, the Supreme Court in Minnesota concluded that the statements made about the doctor were not defamatory and therefore not actionable. And again, this was something that went on for years, and while the doctor felt that it was really important to bring that defamation lawsuit, in the end, the organization and Dr. McKee got nothing out of it. So I think my point in bringing these things up is that you really need to step back, and while you might be really upset about a particular post, there is a time and place for a defamation lawsuit, but I think you need to think hard about it. So what I've got here is, if you're not going to bring a defamation lawsuit, then what should I do in response? So I'm going to talk a little bit about Glassdoor, because Glassdoor I've been hearing about from clients more and more and more. Clients don't like Glassdoor. For those of you that don't know, Glassdoor is a site that provides employees an opportunity to talk about salary, to talk about conditions, to talk about their favorable and unfavorable responses regarding their particular employer. And most employers believe that Glassdoor is simply a rant site. So what I've included here is some information from Glassdoor that says that Glassdoor is not just a rant site, that 70% of employees say that they are okay or satisfied with their job. And I've got to say, I ran a search on Glassdoor with some of our attendees today, and I have to say that most of the information I found was positive, although I did find something negative on each one that I ran. So if you haven't run a search on Glassdoor.com on your organization, I recommend that you do. Glassdoor also says that people cannot post anything they want. They do have acceptable guidelines for what they can or cannot contribute. So these are the review guidelines, and I think it's worth having somebody in your organization go through the review guidelines. if you have a post on Glassdoor that you think is particularly damaging, because in some circumstances, you might be able to go back and say, hey, to Glassdoor, I mean, that, hey, this employee did not follow your guidelines, they didn't follow the examples, and so therefore, we want you to take this down. And under certain circumstances, Glassdoor will do that for you. So what is our practical takeaway on this then? What I really recommend that you do is determine whether or not a response is really warranted, and whether or not you want to take the time and the energy, because it will take time and energy, to try to get a social media site to take your post down, take a particular post down. So the first thing that you can do is ask the review site to remove the post. What you want to be looking for there is this solely for harassment? Is it actually a false statement? What can you focus on to be able to convince the review site to remove the post? And I'm not saying that they're going to do it, but what you want to do is look at the terms and conditions of that particular site, whether it's Glassdoor or Yelp or Angie's List or Craigslist, to determine what the basis might be to remove the post. If you can't get the post removed, then maybe you want to think about writing a neutral response. Glassdoor.com in particular has the ability to set up a free account, and if you set up a free account, you're able to provide a neutral response. And I know that a lot of clients have taken that as their stance, that they always write a response. If you are truly, truly upset in a way that you think you really need to bring a defamation claim, talk to your legal counsel and decide whether or not that's what you want to do, or if you want to demand that the employee remove the post. From a positive side of things, what you really want to do is take action to positively increase your company's brand. You could create your own account on Glassdoor.com. You can maintain it in a way to be able to highlight the good things about your organization. You can create a Google Plus account. That increases if you've got a Google Plus account, it increases your searchability on Google. And so if you've got positive things on your Google Plus account, it's going to increase that. Maintain a positive Facebook or LinkedIn page. Again, trying to highlight those positive things. And my final note is back to some of Nora's comments on making sure you're not running afoul of the NLRA. Make sure that you are not trying to discourage non-supervisory employees from posting negative statements online. We have a lot of clients who say, can't we just tell employees they can't post negative things about us? Can't we just include in a separation agreement a provision that says you can't post negative things about us? The NLRB will take pretty serious problems with that approach, so we don't recommend that you do that. So that is the last thing on protecting your online brand, but we do have some additional questions here that we're going to go on. I know that we are at 1 o'clock, so if some of you have to drop off, we appreciate that, but we've just got a few questions we thought people might be interested in hearing the answers to, since we got a late start here today. I'm going to take this first one because it relates to the online brand. And it says, what can we do about a patient posting a really negative Facebook comment about an employed physician? The reality is, with regard to patient reviews, whether it's on Yelp, whether it's on any one of the many, many medical provider sites, or whether it's on Facebook, is that unless it is false and defamatory, there is probably not a lot that you can do about that post. What we have recommended that organizations do with regard to patient posts is to, if you know who the patient is, reach out to the patient directly and try to have a conversation with that person. If you feel like it's something you need to respond online, then think hard about how you're going to craft that response in a positive way. You may actually, by doing that, convince that patient to remove the information on their But I don't know that you can actually stop an employee or stop a patient from making negative statements.
So I have a couple questions relating to friending patients. The first one is basically, what if the patients are making the friend request to the provider versus the other way around? To me, it goes both ways. So even if it's the provider sending out the friend request or the patient sending out the friend request, we don't want the friend relationship on Facebook. The other question is, what if an employee is Facebook friends with someone prior to them becoming a patient? That's a really great question. What I have typically been including in my social media policies is sort of a little caveat that gets to that relates to, unless you are close personal friends prior to the relationship, or family members too, because obviously you could be Facebook friends with a relative or a very, very dear friend, and then they become a patient at your clinic. That's a different situation.
So this was an interesting one, and it may need to be our last question here. It is, can you terminate an employee if they post untrue, false information about the employer or other employees on social media? Now, that is a very good question. And I think, again, this goes back to how you've crafted your social media policy, frankly, but it also might relate to what you have in your code of conduct or other policies relating to making untrue statements about other people or about the organization. Now, if somebody is making an untrue statement about a client, about a patient, about another employee, and even about your organization, if you absolutely know that it is false and there is no wiggle room there and it's not opinion, you probably have the basis for doing that, and you certainly could terminate as a result. But I would want to step back again to make sure that you were clear on that, because there are so many different ways that that can be interpreted that you wouldn't want to run afoul of some of the laws we've talked about today.
Well, Teresa, thank you so much. Nora, thank you. I just want to apologize quickly for those of you who had to flip between listening on the computer and the phone. My understanding is WebEx had some technological glitch. I know it was outside of our control on this one, so our apologies. I'm a little nervous about the state of the recording on this because that recording is done through WebEx. Hopefully, but if assuming the recording worked well, that will be there and intact. And I know I missed the parts I missed. I'll be listening to it. Only closing announcement, please fill out your evaluations. The only thing you don't even have to mention the technological glitches. We know about those. But we love topic suggestions. We'll be doing PSAs, so that'll be Jim Platt and Katie Douglas doing PSAs on Wednesday, May 13th, same time. So 1 Eastern, noon Central, that's 10 Pacific, and going back to Hawaii is always so hard for me. It's 4 hours, whatever, 4 hours. 8 o'clock in the morning in Hawaii. And I think that covers anything else. Teresa, Nora, do you guys have anything else?
The only thing that I wanted to note is we do have a few questions that we didn't get to, and Nora or I will respond to those to the individuals who sent them to the extent that we can tell, just to make sure that those questions are answered.
And thank you for that. And actually, I think June, we are leaning towards doing probably an overpayment and appeals topic is what we're leaning toward, but we'll see what happens between now and then. So thank you so much, and have a great day.